Hello, hello. Welcome back to another Answers with Autumn. And you see, I have a very special guest with me this week. It is really Answers with Autumn and Michelle. Michelle Coakley was the first attorney to work with our firm and is still with us many years later. Michelle is very experienced and her focus with our firm is employment. So today we are going to be answering lots of questions about working with contractors, W-2 employees, new rules, regulations, making sure that you are totally compliant. And because I do not do much of that work, I know enough to be dangerous and I do not want to say the wrong thing. So Michelle is going to be here and I'm going to be the question asker today, and Michelle is going to be the answerer. So Michelle, thank you for being here.
Glad to be here. Thanks so much. This is my favorite topic to talk about.
Yay. Can you give us like a 30-second background of your experience? What brought you to the firm?
Yes, I practiced at a large firm in Detroit for 13 years, and my specialty there was commercial litigation and specifically employment litigation. And then I also did employment advice, the contracts and the handbooks and all of that stuff for a big firm up in Detroit. And then when my family relocated to Chattanooga, Tennessee, we came here for my husband's job. A mutual friend connected me with Autumn, and it brought me to the firm, and it was a great opportunity for me to dive in and do some intellectual property work, which was what the firm was doing, and then bring my employment expertise to that. And, it has helped us grow with our clients as more and more of our firm's clients have been adding to their teams. It's been a way for me to leverage some of my background before I came to Autumn's firm.
Yay. And I just want to mention, because Michelle has the litigation background, she has truly been in the trenches and seen what it really looks like when people make employment mistakes or when you have an unhappy employee or former contractor, what that really looks like. And I think that brings such a nice perspective to the work with our clients. Like, we try not to be fear mongering and, just scare people, but there are real consequences. And so Michelle's experience and what that looks like when it plays out is just so valuable. All right, Michelle, let's dive in. I'm going to start. I'll mention I was at Amy Porterfield's mastermind a few weeks ago, and I got so many questions about working with contractors. When is it time to change to W-2? What does that all look like? So we're going to start in that area. So first question, I have a contractor who's taking on more and more responsibilities. At what point should I transition them to an employee, and what are the legal implications of that change?
Sure. We get this question all the time. It's probably one of the most common things we work with AWB clients on is making that transition, because a lot of our clients have started with a smaller team. And then as the business has grown, they want to transition them to employees. So if you find yourself in that position, you're right in line with a bunch of other people. The bottom line is, to qualify as a contractor, you have to be able to meet the independent contractor test. There's both federal tests and then there's also state tests. So the legal, easy, short answer is when the contractor can no longer meet the test to be a contractor. And a lot of times that has to do with, how involved they are in your business, essential they are, how you're paying them, et cetera. So first and foremost, if you have a team of contractors and you look at the test and you think, gosh, they've really become so integrated into my business by this point, they're probably not a contractor anymore. Let us work with you and we can help you get that, transitioned over to a W-2 employee. And you asked, what does that look like? Once I decide to do that, we always tell people, talk first to your accountant, make sure that they're on board, because you're going to have to remit payroll taxes, of course. You will almost certainly have to register to do business in a state. If you have, let's say you have a contractor that's maybe in a state different from you, which a lot of our clients do. And I think it's just the way of the work world in 2024. Once you get to that point, you may have to register to do business in those other states, because you're going to have to remit those payroll taxes. So you'll have those responsibilities. You'll also then be an employer. So you'll have to make sure that you're giving employees like the paid leave rights that they're entitled to. We would recommend that you get a handbook in place. We have an employment agreement that we recommend that you use, so that way it's very clear this is at will employment. And yeah, we can help you make that big switch. But
Yeah.
from a day-to-day perspective, their work doesn't need to change all that much.
Yeah. And we went through this at the firm. I'm sure you remember many moons ago, moving from contractors to employees. And I wouldn't say it's hard. It is just administratively, there's some things to do. And lots of our clients have team members that help with that, all the registering in different states, setting up payroll. And it is a little bit more expensive. Like, do you have kind of a back of the napkin, because the employer pays some of those payroll taxes versus the contractor used to have to pay all of those themselves?
Right, exactly. So when they're contractors, the employer isn't paying any of the FICA tax. So then that gets divided. So you'll immediately have that little incremental expense of paying the FICA taxes for your employees, where now you're dividing with them. But it's also a reason sometimes clients tell me that their contractors are resistant to becoming employees. But the good news is I was like, well, they do get a little more than 7% raise as soon as they become an employee, because now they don't have to pay 100% of their FICA responsibility. There's little things in different states too, like you might need some states require workers' compensation insurance when you have one employee. Some don't require it at all. So you just got to know what kind of state that worker is in, and do you need workers' comp in that place? Little things like that. You're going to have to register with the state, so that way you're paying into the unemployment fund for that state in case you have to separate ways with that employee down the road. There's I would say you putting it right. There's a lot of administrative stuff. You need the posters, like those things that once in the olden days when you had your first job and it was hanging in the break room, those posters you need to email those. You need to get those from the state and then email those out to your virtual employees so that they're adequately notified of what their rights are under the applicable employment laws.
Yeah, so this sounds like a lot of things to research and figure out, especially if you have a team in several states. Is that something that you and our other employment lawyer, Katie Nelson, help with?
Oh, all the time.
Yeah.
Every single day. It's like we are always looking at the different state laws based on where the employers are versus the employees. And we have very few clients, I think, who have a team that is all in one place. I think there's the way of the world is that everybody has their employees are scattered across the country, sometimes even internationally. And so we do research and advising for all of those people.
Okay, great. All right, the next question is kind of related. So I follow a lot of HR consultants on social media. I've been hearing them talk about how a recent Department of Labor, DOL, they keep talking about this DOL final ruling that now means you can't work with contractors if they're performing core tasks in your business. And again, since I know enough of to be dangerous, I've been kind of skeptical. Like, is that really true? Is that just something they're fear mongering about? Help us understand what's really changed.
So what came out, it became public last January 2024, and then the rule became effective in March of 2024. And this is a Department of Labor rule that says when you are evaluating under the Fair Labor Standards Act, whether a worker is an employee or a contractor, they came forth with this six-part test. And those tests sometimes change based on which administration is holding, who's appointing the Secretary of Labor. Sometimes these rules sort of change. But what this most recent rule is that there are six factors that you look at to determine whether a worker is an employee or a contractor. And that's just under the Federal Fair Labor Standards Act, which is
And
the
that
law that
applies
requires.
to like overtime, hourly
Exactly. That's
pay.
what sets
Yeah.
minimum wage, overtime, rules like that. So at a federal level, that final rule, while it does apply to all federal and everyone who's covered under the Fair Labor Standards Act, which is most employers, as long as you have revenue of at least $500,000 a year, but it does not replace state law on this topic. So this is not a get out of jail free card on the California AB test, if that's what you were thinking, because there is still state law that covers employees. And so if you've got an employee working in California or Colorado or any other state, you still need to make sure that you're following the independent contractor laws of that state. Because if that worker goes and files for unemployment or goes and files for a workers' comp claim, that's going to be under the state umbrella. So, the short answer is there is that six-factor test for the Department of Labor, but also we got to juggle that with the same state test that we always have been using. And the important things that I would say that are most relevant, I think, to our clients of the six factors are the opportunity for loss or profit. That is a big one because if you want to pay your contractors on an hourly basis, there really isn't an opportunity for them to earn a profit or suffer a loss, like flat fee or retainer place where you're just paying them a flat fee to do a job. And whether it takes them 10 hours, 100 hours, if they hire a team to work under them to do it, that's all within their control. That looks more like a contractor. Also, how integral the worker's work is into your business is a factor under that six factor test, and the permanence of the relationship. So that's like the law is set up to make it easy for you to hire a contractor to come in and do an ad hoc project.
Yeah.
I need a new website. I need a whole new marketing campaign, something like that. It's going to come in, they're going to swoop in, do the work, swoop out. But if you're using a contractor to run your day-to-day business, that's where you need to be more careful. And that's where you need to make sure that you actually are meeting the test, because the more permanent they are, the more they look like an employee than a contractor.
Yeah, I always get nervous when I'm speaking with a business owner and they tell me that their COO is a contractor. And I'm like, oh my gosh, they are running your business on a day-to-day basis. That really sounds more like an employee classification than a contractor for that reason. Yeah. And then tell me, you mentioned all these state tests. So, excuse me, when an online business owner or coach or course creator comes to you and says like, here's my team. I've got, 4 people in 3 different states. Who should be a contractor? Who should be an employee? Tell me, like, walk me through how you look at that analysis.
First thing we ask for, so when we're helping a client work through that, we say, give us your roster. We want to know what everyone is doing. How are they paid? How much are they paid? Where are they doing the work, city and state? Because there's even some local ordinances in some states on this stuff. So we will look at the law of where's the work really happening? That's the question. So like if I'm working in Los Angeles and my boss is in St. Louis, Missouri, like it's going to be California and LA law that's going to govern that relationship. So we're going to need to know, what are they doing? How much control, how much autonomy? What does their day-to-day look like? How much do they have to report back the employer? Or are they really pretty siloed? So we will look at sort of the whole relationship, but really get into the nitty-gritty of how are they paid and where are they located. Those
Yes,
are
I know
two
something I've heard.
quantifiable things.
Yeah, I've heard you talk too about like how much training are you providing, or how strict are you with the way they do their job? Like, do they have to comply with, rules that you have in place? So tell me what that looks like.
Yeah. So if you talk about employees versus contractors, a lot of times you hear people talk about control and how much control are you exerting over the worker. And that really gets down to, some people will say, oh, well, I let this person work, whatever time of day they want. I'm like, okay, control has somewhat to do with the time of day they're doing the work, but it also has to do with how is the work getting done. If you have, for example, a customer service representative and you're like, okay, here's the playbook. Like, when a complaint comes in, here's response number one, and then here's response number two, and you have sort of dictated to them how the work is going to get done, you are exerting control over that work, even if they're doing it on their own personal schedule. So the easy, real quick, generalistic rule is, I say, if you tell somebody what to do, that's a contractor. If you tell somebody how to do it, that's an employee. So if I just tell a contractor, listen, I want you to provide this deliverable to me. I need it 3 months from now. How you get there, what methods you use, who you delegate to, what other resources you pull in, it's fine. You say, I want this deliverable. I want it in 3 weeks' time, and I'm going to pay you $1,000 for it. That looks like a contractor relationship because you have stepped out of how they move that product from point A to point B.
That all makes sense. Okay, moving again, we mentioned that the Department of Labor has, hour and pay, overtime. That's kind of their jurisdiction. So I heard recently that they are raising minimum salary requirements for an employee to be exempt from overtime. So tell me everything I need to know about this change.
Yeah, yeah. So that came, so for an employee to be exempt from overtime, the terminology here is always confusing. Exempt means you don't get overtime, non-exempt means you do get overtime. So for an employee, so if you say, I've got this admin who's working for me and I don't want to have to track their hours. I just want to give her this amount of time to work and say work 40 hours in the week and then be done. If you want that person to be exempt from overtime pay, they have to both have a certain level of responsibility. There's two components to it. There's a salary side of the test and there's a duty side of the test. So they need to have certain sufficient responsibilities to be exempt from overtime. This recent change that Autumn you're talking about, it has to do with the salary half of the test, which is, even if I have all the responsibility in the world, if I don't make a certain amount of money, I'm not considered exempt under federal law. And the opposite is true. Even if I make a lot of money, I have to have certain responsibilities for them to balance out. So for a long, long time, the salary was just under $36,000 a year to be exempt from overtime pay. They recently bumped it in July, and then January 1st, it's going to go up to almost $59,000 a year.
So
That's a
almost
pretty
double.
dramatic.
That is a huge
Yeah,
change.
it's
Yeah.
a big jump. So if you've got employees who you have classified as exempt and they're making in that $40,000 to $50,000 range, you will need to bump their salary on January 1st for them to maintain their exempt status, or you'll have to reclassify them as non-exempt, which is fine to do too. You just then have to track their hours. So if you have non-exempt employees and the Department of Labor ever audits you to make sure you have to be able to show for all my non-exempt employees, I tracked how many hours they worked, and I paid them overtime if they were entitled to it.
Yeah, and this is something we've had to do here at the firm. There are rules that affect us, like our paralegals cannot be exempt just because of their responsibilities, their duties. And then some of our administrative team are kind of in that same bucket. So I will say administratively, like we talked about the administrative burden of having employees, this one is not a super heavy lift. We just ask everyone to start a timer, kind of clock in and clock out. And then we do pay overtime, which is, I would say, fairly infrequent with the kind of work that we do. So, if you do find that you're routinely having people who are working 50, 60 hours a week, and they are exempt from overtime and they are in this, lower salary range, this is something you might want to really look at more carefully. All right, so this is an interesting one that has come up with a few of our clients. Considering hiring someone for a sensitive position, looking at candidates, what steps are allowed or must be followed to conduct a background check? We don't want to violate privacy laws, and so this can be a tricky situation.
Yeah, this became a really popular topic, I don't know, a decade or so ago with the whole ban the box laws. So the best practice, if you want to conduct a background check on a new employee or candidate, is you should not do that until a conditional offer of employment has been extended to that person. So don't ask for a background check at the application stage. That is not the time. You want to evaluate all of your applicants. That is not the time to ask them, for all of their arrest records, et cetera, because there are, the EOC has done research on this, and there are certain minority groups who tend to have higher arrest records than others. And then that takes them out of employment opportunities. So because of some systemic discrimination that may exist there, the EEOC doesn't want that to carry over into the workplace. So with that in mind, don't get into background checks, criminal history, anything at the application stage. Once you have narrowed it down and you've got your top candidate, you can extend that person a conditional offer of employment where you say, I'm offering you this job conditioned on you passing this background check. Then the applicant gives their consent to have that background check, to which you must get their consent. So once you have their consent, then go ahead and run the background check. And you have to comply with the Fair Credit Reporting Act when you do that. And if any negative information comes back on the background check that causes you to withdraw the offer of employment, you have to follow the FTC rules to give that person notice of the adverse employment action you are taking based on the background check so that they can go dispute the accuracy of the information if it's not been reported correctly, et cetera. So there is a process. Just hold that process until you've gotten your candidate and then make a conditional offer of employment.
Okay, so basically, if you are adding a background check earlier in the process, you're kind of opening yourself up potentially to a hiring discrimination claim, to a lawsuit.
Exactly.
Yeah.
Exactly. You should not ask for arrest records and stuff on your job applications, because then if you're automatically disqualifying, there is research that shows that certain segments of this population have higher arrest records based on nothing more than sometimes their inclusion in that group. And we don't want any sort of that systemic bias to carry over into the employment. So don't make those kinds of decisions at the application stage. You wait until the end. Choose your best candidate based on their ability to serve your organization well, for their ability to do the job well. And then at that point, that's when you do the background check.
Okay. We want to avoid any potential lawsuits that we can.
That's right. No discrimination. We don't want to discriminate.
Yes. All right. Kind of along those same lines, I want to ensure that my contractors and employees don't take my clients. or don't take my trade secrets to a competitor. When anytime you have an employee or contractor, you're kind of opening your vault to all of your processes and systems and your special sauces. So how can we have legally enforceable non-compete agreements? I know there's been a lot of news about non-competes being banned. What is kind of, we're recording this in October 2024. What is the current status of things when it comes to non-competes?
So the current status on non-competes, there was that the Federal Trade Commission tried to pass that rule that was supposed to take effect in early September that would have imposed a national non-compete and put us all sort of on the same playing field. That rule was found to be outside the FTC's jurisdiction. It's currently on a circuit. So while we're sitting and waiting for the Fifth Circuit of Appeals to make a ruling on that FTC rule, we are back where we were right before it came out, which is in a patchwork of state laws on this topic, and they run the gamut. There are some states that say you can have a non-compete as long as it's reasonable with respect to time and geography and scope. There are some states that say you cannot have a non-compete. There are some in the middle that say you can have a non-compete only if the person makes at least a certain amount of money. And those are usually, sometimes those are high, like six-figure amounts. Sometimes you can have it only if you also offer the person garden leave. There's little tripping hazards all along the way where you can have a non-compete, but if you advise the person to consult an attorney beforehand and gave them at least 14 days to think about it before they signed it. So I hope if you take nothing else from this conversation, what you need to take from it is that there is no one size fits all rule on non-competes in the United States right now. So while we wait to see if that FTC rule comes into effect and evens that playing field a little bit more, what you need to know is that if you want to have a non-compete or a non-solicitation obligation imposed on an employee, definitely talk to a lawyer and say, here's where the employee is. What is the rule in their state? And we have clients that kind of do different things on this. Some clients say, I want as much protection as I can get from everybody I can get it, knowing that I may have different rules among my team. Some clients say, no, I want everybody on my team covered by the same rule, which then means we have to figure out who, which state has the most pro-employee or, the hardest test to meet. And then we put everybody on that program and say, okay, this is the obligation, this is what is required for, say, Colorado. So everybody goes under that rule. So those are some different ways to approach it. You also mentioned trade secrets, confidentiality. There's a Uniform Trade Secret Act, and misappropriating trade secrets is widely enforceable across the United States at the state and federal
That's
level.
really separate from a non-compete issue.
Exactly. So, Mike, when it comes to your trade secrets and stuff, if an employee has misappropriated a trade secret, you should definitely talk to a lawyer because you probably have grounds to sue them either under statute or under a contract that you have with them. But the one caveat I would say to that is make sure you've treated your trade secret like a trade secret. If it's widely available, if you haven't taken any steps to protect it and to limit its access to the people within your organization who are on a need to know basis, it's going to be harder for you to convince a court that that is in fact a trade secret and not just something that's generally known. So if you take anything from this, I would say, okay, sit down and say, what's the secret sauce? What are your customer lists? What is that important proprietary information to your organization? And then take a minute to say, have I restricted access to that to people on a need to know basis? And if not, maybe I should do that. So then if I ever need to argue that's a trade secret, I'm in a better position to do that.
And that could be as simple as, password protecting some things, or, if you've got, like, we use Dropbox, a lot of our clients use Google Drive, making sure that your permissions are correct. So maybe, if you've got an administrative team, they don't need access to what the sales team needs access to, or what your operations needs access to as far as your, policies and procedures. So I think this is another one where it's not a heavy lift. It's not that difficult. But if you're wanting to claim something as a trade secret, you have to really keep it secret. Okay, great. And one other thing you mentioned was non-solicitation. So tell me how that is different or the same, or how that fits in here when we're thinking about a non-compete.
Yeah. So if you're looking at one of these agreements, they all sort of generally fall under this bucket called restrictive covenants. And there's different levels. There's the non-compete, which is usually the most restrictive on the employee. And that's the part of the contract that says during their employment with you and for a year after, they can't go work for one of your competitors, or they can't work in this line of business. That's a non-compete. That's telling them they can't go work for somebody else besides you. A non-solicitation, there's usually two components to that. One is employees and one is clients. So non-solicitation is you can't solicit my clients for a year after you leave my place of employment. And so that's a little bit less restrictive than a non-compete because it doesn't prevent somebody from going and getting another job. It just says they can't poach your people. But even in some places, like Colorado, for example, there are states, like I think of Oregon, Washington, you have to earn a certain amount of money per year before you can be covered by a customer non-solicitation obligation. Then there's the other side to that is employees that says you won't poach our employees, you won't try to draw away, convince them to come work at your new place of employment. So that's the difference between non-compete and non-solicitation. And then the last part of that is confidentiality, telling them, okay, the proprietary and trade secret information that you learn when you're working here can only be used while you're working here. And of the three, the confidentiality is the easiest to enforce, the non-compete is the hardest to enforce, and non-solicitation falls in the middle.
Okay. Thank you for clearing all that up. I get a lot of questions about that. Okay, so something else that came up with my mastermind, I think especially our clients who are at that, 7 to 8 figure mark, a lot of them have larger teams. And so they start thinking about, I am tired of all the headache of running, keeping track of all these different laws and registering and all the paperwork that comes with running a team. And they start to ask about a PEO or an EOR. So tell me when that makes sense. What are the benefits, any drawbacks to thinking about, pulling that in to help you with some of this HR work?
Sure. So the difference between an EOR is an employer of record and a PEO is a professional employer organization. So an employer of record means that the employer of record is the one and only employer of the employee. And when we see that most frequently is when our clients want to hire somebody who's in another country and they are not interested in becoming an employer in Austria or Japan or wherever this person is that they want to pull onto their team. So what you do is they'll often hire a third party employer of record service, and that employer, that is the entity that employs the individual, and then your contract with them then lets the individual provide services for you. So that's an EOR. You want somebody overseas, look into EOR options. A PEO, professional employer organization, is really outsourcing your HR. I mean, that is, you become co-employer with this, right? So in a PEO, you and that company together are co-employers of the employee. So you can both bear liability in case there's any sort of discrimination, or if there's any kind of employment claim that comes up, you'll have joint liability with that individual or with that organization, I mean. So that's the difference. But so a PEO is for the people who are like, I don't want to have to hire an HR person. I don't want somebody who has to handle all the onboarding. I don't want somebody who's going to manage all of the leave requests, et cetera, like that. That's when a PEO can come in and help you. But a lot of our clients, do that themselves. That is a hat that a lot of COOs wear at organizations we work with.
The other thing that I've heard, and this is not as relevant to our clients, because I think in online business, your workers' comp insurance is usually fairly low because we're not a super risky industry. But I have actually a guy in my same office complex that we worked with who runs a PEO mostly in the transportation business. So like for trucking companies, because sometimes those PEOs can get a better deal on insurance policies because they have a large, pool of employees that they're covering. So I find, again, not relevant to us, but if you hear about that, like, oh, you can get a better deal on some things, that may or may not be really a good savings for you. The other thing that has come up is I had people ask me, well, the PEO handles my HR, so what do I need a lawyer for? Aren't they doing all of the things we've been talking about making sure my contractors and employees are properly classified and that I have the right agreements in place, that I have a handbook. So tell me how our firm typically is going to interact when one of our clients has a PEO.
Yeah, we have worked with a couple clients who have PEOs, and typically what we're doing is the legal side. Like the way I would describe it is I'd say the PEO is handling more of the day-to-day compliance. So day to day, making sure that you're doing employee reviews, like the annual reviews and the salary reviews, and they're managing the nuts and bolts of leave time off and stuff like that. making sure that you're complying with the minimum wage in every state, et cetera. The PEO is good at all of that compliance type work. And so that in most instances, when we work with a PEO, they're doing that. They're making sure a new employee gets the right posters for the state they're in, et cetera, updating those every year, stuff like that. We typically then work more when there's a legal question. There's a contract that needs to get reviewed or a legal claim comes in. Fortunately, we've had the good fortune of not having too many
Knocking
clients
on wood.
have we've kept a lot of people out of hot water, so we haven't had too many employment claims. But if something comes in, like a charge of discrimination or a lawsuit or an allegation, that's typically when we get involved.
Yeah, I would say also kind of answering tricky questions, like if a employee has a mental health issue, or we've had clients definitely who have had employees become pregnant and they want to do the right thing, but they don't know what the right thing is. I have seen, what comes through our inbox is a lot of
Yep.
those kinds of questions that it's more just like advising and helping them, figure out how to make a good decision. I don't know that someone with a PEO would necessarily be doing that kind of hand holding, which I think
Right.
our clients really count on us for.
Yes.
Yeah. And then kind of the same question I mentioned I follow lots of HR consultants. What would you say is the distinction between kind of maybe where your work ends and an HR consultant may come in? I know that can be a bit of a gray or a fuzzy line, but what have you seen most commonly?
When I've worked with PEOs, I mean, we try to communicate pretty well with them. And it's what I would say is really that compliance versus legal is kind of like where that line, like if there's anything compliance, like, okay, you're onboarding somebody, you're going to make sure that they get that all the paperwork gets signed, that um, that
You're
they
sending the right
acknowledge the
forms to
handbook.
the state. Yeah,
Exactly. All the paperwork, like you need the I-9s and all that. So the PEO is really great about all of that. And then we will typically come in. But lots of times, like if they say, okay, there's an update coming out, or if something needs to get updated, or if there's a legal question, that will often come to us. Or they'll ask us, they'll say, hey, will you create the contract or update this contract? Or they'll have us do the actual legal work. And then they will handle a lot of the administrative side of all the employment compliance, which is it's a lift. It can be a lift. It doesn't have to be, but it can be a lift depending on the size of your team.
for sure. Okay, so moving into, I've got a team, I've got maybe employees in a couple of different states, maybe a handful of contractors, and I want to establish clear policies and procedures. I think I know I definitely felt this, like, I don't want to be corporate. I just like trust everybody to do their job and be a grown up. But I think most of us find when your team hits a certain inflection point, both because of employment laws, where you want to make sure you're even-handed to avoid any discrimination claims, but those policies and procedures start to be really valuable and help you actually run your business better. So a lot of times we're looking at putting those into an employee handbook. So tell me, like, what are you typically seeing included to make sure, again, it's helpful for the employees to know how things work, but a handbook, as I understand it, really is also helpful in protecting the business.
100%. I tell businesses all the time, because it's such a big document, it feels like a lot to put a handbook together. But there are really important protections for the business in a handbook. Like, for example, that's where your at-will employment policy is probably going to be, which is critically important. We talked a few minutes ago about exempt employees. There's this safe harbor payroll provision in there that you've probably seen in a handbook but didn't realize it was legally significant. But it helps you as the employer in case you ever make a mistake on an exempt employee's payroll by having that policy in there that gives them an opportunity to complain that you made an improper deduction. You don't sacrifice their exempt status. So there are some little things in the handbook that really do help the employer. Sexual harassment policy, 100%. That you need to have a very clear complaint procedure so that you tell your people if you feel that you've been the victim of harassment or discrimination in any way, shape, or form, here's how you report it. That helps protect the business. So that by giving your employees a roadmap for how they should address issues, that helps protect you in case a claim comes up down the road, but you were never made aware of it because they didn't follow your procedures. So a big question that always comes up too, I get this question all the time. What goes in the employment agreement versus what goes in the handbook? And I always explain to people, I was like, it comes down to what is your recourse. What you want in the contract are the things like if the employee doesn't do it and I need to sue them. For example, if they are taking my trade secrets and spreading them around town, they have violated their confidentiality obligation to me. I need to be able to file a lawsuit quickly for breach of contract against that employee. On the other hand, a handbook, this is not a contract. We even say in the handbook, it's not a contract. As the employer, I can change any of these policies anytime I want, and I don't need your permission, employee, to do that. So
But some
your
flexibility in the handbook. Yeah.
there's more flexibility in the handbook for you as the employer, but it's also your recourse if an employee violates it, is you terminate their employment. So that's why I'm like, okay, what goes in the contract is if I need to take you to court over this, what goes in the handbook is if this isn't working out, I'm going to terminate your employment. And I would say this, handbooks, it feels like a lot of work because they're good size, but 85% of it is pretty standard. The if I can give one tip to employers, like how, Michelle, tell me, how can I create a handbook in less time with less effort? I would say the part of the handbook we spend the most amount of time talking to employers about and trying to get right is the paid time off policy. How do you get paid time off? How is it calculated? That and leave policies, like a parental leave policy or a medical leave policy. How you handle employees getting time away from work is probably the single hardest thing for employers to wrap their heads around. And so we're happy to, and sometimes we found the quickest way to do this is we get on a call with a client and let's just talk through it for a half hour or an hour. And let's just run through, let me pose questions to you and scenarios to you that you haven't thought about. And let's try to just figure out, okay, what should the paid time off look like? Because once we pin all that down, the rest of the handbook goes pretty quickly because it's pretty standard. So in the paid time off is about like what suits your business? What's your organization? What's your culture?
Yeah. One thing that I really love about your work with our clients is that we do have a really clear process. It's easy for someone to come to us and work on a handbook. We have kind of a framework in place that we can then plug in, like you said, to their culture and their desires. And you and Katie both have so much experience. You've seen so many of those scenarios that I used to joke, I had a wedding planner that I worked with who would say, every term in her contract had a bride's name written on it. Like you've seen those kind of worst case scenarios
Mhm.
that hopefully some of our clients will never see. But you can help them kind of think through that and make sure that their policy will kind of hold up in those, unusual circumstances.
That's right. That's
Yeah.
right. So I would say this. I'd say you spend an hour thinking about your paid time off policy and then say, okay, I'm ready for my handbook.
Yeah.
And it will go much smoother.
Exactly. Okay, great. And then we're going to wrap up with kind of the tail end of an employment relationship, which is what do I need to know about firing someone? So whether they're a W-2 employee or a contractor, what documentation or steps do I need to make sure that I'm taking? I would say this is another thing that we get calls about, like, I need to fire this person today. What do I need to do to make sure I'm not messing anything up? Because
Right.
this is
Right.
a tricky
So
area.
I'll start with the easy one, which is the contractor. If you're like, I've got a contractor, we need to part ways. The first thing I'm going to say is send me the written agreement you have with that contractor. I really hope you have a written agreement with that contractor. If you don't, that's my plug to make sure you get a written agreement with your contractors today. And then if you don't, if you have the written agreement with your contractor and you say you want to part ways, I'm going to say, what does the contract say about how to terminate? How much notice does each side have to get? We're going to follow the contract. We're going to do it by the letter and then part ways. And that's just basically like you ending a relationship with another business. That's the easier of the two. When a client calls me and says, Michelle, I need to fire an employee, I send them a bunch of questions. I've got a list that we have saved in Asana that I'm like, here's my list of questions. And I'm gently interrogating you, I'm turning over rocks to see what I want to know is there any potential legal claim that this employee has? Did they just come off a medical leave? Did they just return from having a child? Have they made a complaint? Are they potentially a whistleblower? What I'm trying to figure out is this person a whistleblower? Is this person potentially have a discrimination claim? Anything like that. And a lot of the reason I'm doing that, and that comes from just take this whole thing full circle. I was a litigator once upon a time for employment law, for employment cases. And I will tell you, the retaliation claim is harder to get rid of than the underlying discrimination or harassment claim because it's easier to prove that somebody wasn't discriminated against than it was to prove I fired you because you made the complaint, even if it wasn't a valid complaint. So what I'm trying to do when I'm pressing employers on that is I'm trying to prevent you from getting on the wrong side of a retaliation claim. So that's what I'm trying to figure out is what has this employee made any noises that we need to be concerned about so that we do not find that you're a defendant in a retaliation lawsuit. So we ask a bunch of questions. Once we sort of clear that hurdle, then I say, okay, what's their employment file look like? What are their performance reviews? How have you documented? Why do you want to let them go? And then I'm going to push you and say, has somebody else? Have you ever had to let somebody else go? Well, how did you treat that person? What I'm trying to do is figure out, are you discriminating? Are you treating this person different than the last person? And I always encourage my clients, I'm like, let's look at their file with neutral eyes. Like, just pretend you're a juror sitting in a box. Like if I'm flipping through this, do I say, yep, this paints a pretty good picture of what was going wrong here and why this relationship should be terminated. And if it's real thin, I'm going to say, let's just take a minute and document. It's okay. All the emails or you say, oh, I've asked this person 25 times to do the same thing.
Right.
They're not doing it. Great. I'm glad you have those emails. Let's put them in the file. The other thing people need to know is that in a lot of states, an employee has a right to review their personnel file. So before we terminate them, we want to make sure all that documentation goes into the file. So that way, if you fire them and they say, I want a copy of my personnel file, you can hand it to them and it's all right there. The whole basis for your decision is right there in black and white.
Now, I heard you mention earlier how important it is to have an at-will employment policy, which I understand at-will employment means you can fire someone for any reason except a prohibited reason. So how does that kind of play in here with this? Why can't I just, if they're an at-will employee, why can't I just fire them because I didn't like their blue shirt?
That's a fine reason. So it's okay to fire somebody, but you don't like the jacket I wore today. So that's it. I'm out of here. That's an okay reason because that's not a protected class. Like, so the way employment lawyers talk about this is at will employment means you can fire for good reason, bad reason, no reason, just not an illegal reason. An illegal reason means like there are certain things that employees are protected. Whistleblowers, they're protected from discrimination, they're protected from
Like race,
retaliation.
gender, religion, those
That's
disabilities,
right.
protected classes.
There are protected classes, exactly. Age, race, gender, all of those things. And so, but they're also protected if they made a whistleblower complaint or they just came off a maternity leave or something like that. If you can't fire somebody because they exercised their rights under the law. And employment law is very state specific. So there may be prohibitions on fire, like for example, in the state of California what somebody does on their own personal time. You can't fire somebody because they're moonlighting, because this person also is an Uber driver in the evenings. And you're like, that's it, I'm firing them for that. Well, no, that's protected. So before you terminate an employee, what I always say is let's make sure the thing you're firing them for is not protected by the law. That's the question we're trying to answer. So once we've cleared that and we're like, okay, the thing you're firing them for is not protected under the law, that's when that at will employment kicks in. And it can be that they were doing a poor job or they were late on one day, or you didn't like the way they looked at you. All of those are perfectly acceptable reasons as long as they're not illegal.
Yes, and as we are in a political season, I have heard, and this may be state specific, you know much better than I do, but that there are free speech protections for employees as well. So if I am, bashing a political candidate that my boss likes, or I am bashing the company that I work for on social media, there can still be some protection. So I think your work is so valuable in helping make sure that like the reason we tell the employee is, like you say, if there's 6 reasons that you could terminate someone, let's pick the one that is going to keep us on the right side of the law.
We're gonna focus on, yes, this is a legally, like this reason
Legally
is a
defensible.
perfectly legal reason. It's a legally defensible reason, yes, to terminate somebody.
Okay, great. Well, that will wrap us up. Thank you so, so much, Michelle, for sharing your brilliance with us today. If you are interested in more information like this, I've got a couple of resources for you. So the first one is totally free. We have an incredible newsletter that we send out weekly that's going to include legal updates. So when these new rules are coming out and changes are happening, we're going to keep you updated. We'll include tips and tricks. It's called the CEO Legal Brief. And you can find that at awbfirm.com/newsletter. newsletter, very easy to sign up for. And then if you are looking to get some more personal help, if you would like to have a Michelle in your corner on speed dial when you have these questions, we are onboarding new clients through the end of November. So we don't onboard new clients in December because we found our current clients have lots of things they need us to do. We want to make sure we save room for them. But we are onboarding in November. So if you're interested in some one-on-one support, go to awbfirm.com and you can find a short form to fill out, get the ball rolling, and then we'll set up a call and see if we're a good fit to support you. So thank you for joining us. We will be back next month with more Answers with Autumn and perhaps another team member. Thanks again, Michelle. Bye-bye.
Anytime, Autumn.